Rice IT is a global software services company that provides software consulting, staffing, and governance risk compliance GRC services. With over 1,000 employees and consultants in the United States, it focuses on cloud, workflow automation, and business intelligence. Our subsidiaries include iTech, SmartWorks, Cox Little, and Excel Group. My name is Dobrina Ustun, and I'm the General Counsel at Rice IT Solutions. I oversee all in-house immigration and compliance matter for our company. With over 10 years of experience in business immigration, I have advised many companies and provided them with innovative corporate immigration solutions. And at Rice IT, we are proud to have a dedicated team of senior immigration law experts who provide our employees with top-notch immigration assistance. And today, it is my pleasure to introduce one of our star employees and immigration experts, Lilly Suthakar. Lilly is the immigration program manager for all immigrant visa matters for Rice IT Solutions. She's a certified paralegal and has business and family law immigration experience with law firms and IT consulting companies. At Rice IT, she oversees the Green Card program, including filing the PWD, running the AdWords, filing PERM, I-140, and adjustment of status applications. Lilly, thank you for joining us today. I will share a secret here with our audience that prior to working in the immigration field, you were a software engineer. Can you tell us how your experience as engineer prepared you and helped you to launch your immigration career?
Thank you, Dobrina. It's a pleasure being here. My engineering background comes in handy when I navigate through the experience letters, the education transcripts of employees, and look through the education evaluation and to see which job description would best route them for their perm process. So this engineering background does come handy, and I'm able to differentiate the different job roles and the technologies that they have in background.
And how long did you work as a software engineer? How many years?
My tenure with software engineer is very less. It is it's below a year. And I have also worked as an HR prior joining to the law firm. I have my experience as an HR and an operation analyst, which also helps me to understand the whole process of immigration when it comes to the bigger picture.
Okay, and your software engineer experience, was it here in the United States or was it from India?
My software engineering was in India. Was my first job after my graduation with my engineering degree.
Okay, perfect. Well, I'm sure that that definitely helps when it comes to understanding and drafting some of these PERM applications. So speaking of PERM, can you talk about current processing times and what's happening in the world of PERM nowadays? I know that there's a lot of anxiety out there, so we would want to hear from you. What are you seeing?
Yes, you're right, Dobrina. There is a lot of anxiety, and the cause of the anxiety is the delays from the DOL. So the DOL has told that the National Prevailing Wage Center is processing the PWDs that are filed in January 2022, and the DOL is processing the PERM filed in September 2022 and earlier. On an average, the DOL is taking over 8.5 months to adjudicate a PERM, and for a perm to be certified, it's more than 8 months. And we are seeing similar patterns with PWDs too. So this does cause a lot of anxiety among our employees.
Yeah, and I mean, from what I see, sometimes we have to wait about 13 months, 14 months to get the PERM certified, which is very unusual. I remember prior to COVID, it was about 3 to 4 months, and you'll have your PERM certified, and about 2 months for the PWD. And unfortunately, these days are long gone. So now we are dealing with the delays, and sometimes it's like 2 years and a half. that we need for somebody to go through the PWD and the PERM process, which is unfortunate. Um, can you walk us through the PERM process at Rice IT and share some of our best practices?
Yes, Dobrina. So you are right. PERM is taking quite long, and it is an overhaul process. It's not as straightforward or as simple as other streams of immigrations that we've seen. So at Rise, we have a unique and a well-structured, transparent process, which makes the whole system very seamless and stress-free for the employees. Right at the beginning of the whole process, we give a memo to the employees, which gives the whole blueprint of the whole process to the employees upfront. And it also gives them the approximate timelines that will be followed or that can be expected in each step. So the employees can go through the memo, and if they have any questions, they reach out to us. And at any given point, even at the later stage, because it takes quite some time, if they have questions, they can always look back at their memo. Next, we ask the employees to fill in a requirement sheet. The requirement sheet goes out to the email, which gives them a very brief instructions on what are the documents that are required for filing their PERM and their 140s. So this gives them an upfront information that is required. This requirement sheet is like a bird's eye view of their experience and their education that they have. At this point, we collect all the documents that's required, even though it is considered an early stage. We do collect it as a best practice. We collect all their education certifications and diploma certificates, anything, and their education evaluation if required, and if they and all the experience letters of the employees. So when it comes to experience letter, that plays a major role in the whole PERM process. So what is a best experience letter is it has to have the job title which the employee performed in the prior employer in the employer's letterhead, and it should also have the job duties and the tenure which they served in that particular organization. So, in case an employee lets us know ahead of time that they do not have the experience letter, we request them to get any affidavit from their coworkers, two coworkers' affidavit, and any other form of emails that have been sent by the employees to collect the experience letters will also suffice at this point. And also, we request them to get any pay stubs that they have during their tenure in that particular organization. And this helps us to avoid any roadblocks on later stage. Once we get all this information, we try to understand the job description and the role the sponsored employee will fit in. And based on those information, we will draft the PWD. And once the PWD is drafted and filed with the DOL, it's a waiting period for us. And once we have it determined, we run the recruitment process. So the recruitment process ideally is to test the labor market. So in the recruitment stage, we run the adverts with two Sunday morning newspapers, on two consecutive Sundays, and a local newspaper. And we also run it in DICE websites or any other job search websites, as well as we run it in our own in-house websites. And we also post them in the state workforce agency website, and we wait to check the job market. And as soon as the advertising period is done, we wait for another 30 days as a cooling period. So once this cooling period is also done, we would work on their ETA 9089, which is a PERM. So once we work on the PERM form for the employee, we run it through them. We make sure that the information provided in is truthful, and then we submit it. So once the PERM is submitted, it is again another waiting period of 8 plus months. And once the PERM is certified, we will file the 140 with the USCIS.
Okay, thank you. Yeah, thank you for that answer. A few times you mentioned waiting period 5 months, and we already talked about how long it takes nowadays. And given the process the company has, that the employee has to go through, and all the documentation and the evidence that they need to provide us, Once it's filed, this is one of the most common questions from employees and other interested party in the company. Is like, where can I check my status? Like, can I call DOL and ask them, where's my application? Why is this still pending? Is there something wrong with it? Is there such a place? And if yes, where?
You are right, Dobrina. We do get a lot of calls from anxious employees about where to check their PWD or PERM status. But when it comes to PWD, both the employee as well as the employer can check the status in flag.dol.gov website with the PWD number that's provided. But when it comes to PERM, only the employer can check the status by logging into the DOL website. And there are a couple of websites which claim to provide the PERM status based on the PERM number if they give. But unfortunately, they are not true and not accurate. We have seen such scenarios in the past too, and they are not accurate, wherein the employees claim that they have seen in a particular site that their PERM is determined, but in reality, it wouldn't have been determined. So it is a best practice to wait for the employees for wait for the employees. So when the both PWD and PERM gets determined, the employer will get an email from the respective organizations, and we would in Rise IT we would reach back to the employees saying that it has been determined,
Okay, yeah, that's
and we will walk them. Yeah, we would not walk them through the next steps that is required.
Yeah, that's really helpful because I know that in the world of permanent immigration, a lot of people think that it's and they can just go to a website and it will give them the date when the perm will be determined or the PWD. But when it comes to the Department of Labor, unfortunately, we don't have or they don't have that system. In terms of H-1B workers, they're limited to 6 consecutive years in H-1B status. Given the perm process is so slow nowadays, and we have that limitation of 6 years on H-1B, a lot of H-1B workers are running out of time. What are some ways to qualify for an H-1B extension post the 6th year?
Yes, you're right. There's a lot of employees who would run into beyond the 6 year period. But the good practice is always to file way ahead of time as soon as possible. But if for any reason a sponsored employee cannot apply on time for their H1B, and if they are running out of and for any reason possible, if they don't qualify for an H1B extension, they can do two things. First is they can show that the perm with the has been pending for more than 366 days. This makes them eligible to file for another 12 months extension beyond the 6 years period. Or the other alternative is that they have to wait for the perm to be approved. Once the perm is approved, they can apply for the I-114 premium and show that the dates are not current and apply for another 3 year extension.
Right. So it looks like we have two options, and I want to say two very limited options that sometimes people don't qualify for. Assuming that they don't qualify for the post 6 year extension, what is available for them?
The sponsored employees can leave the country and wait outside the country. And as soon as the I-140 is approved, they can file a cap exempt H-1B and re-enter the country. Or if for any reason they couldn't leave the country, the sponsored employee can stay in the US and file an I-539 for a change of status before their H-1B expires. But this comes with a caveat that they would not be able to work in their change of status.
Yeah, that's correct, and I don't think many people are taking that option. But it is an option. It is available. It is doable. It is legal. People can consider. One thing I just wanted to add for when they go outside the United States, sometimes we have employees where they would want to go to a different country and wait for the perm to be certified in that particular country. One thing to remember, though, is let's say if you go to Mexico, and you want to work from there, you have to be authorized to work in Mexico or any other country, unless it's your home country. So sometimes people forget that, and they just assume that I can show up in any country and just work there until my PERM is certified. Unfortunately, that's not the case. Okay, I think that covers PERM. Thank you for providing all those details. Let's switch gears and talk briefly about the I-140 process. Can you share with us some do's and don'ts in terms of filing the I-140?
I-140 is the second stage of the long green card process, and it is submitted in the USCIS once the PERM is certified. This is required to prove that the individual sponsored employee has the education and experience for the role and demonstrates the physical health of the organization to support the salary. It is very important to select the appropriate green card preference category for the while filing the I-140. There are 5 categories available, so out of which comes in line with the PERM that has been approved has to be selected. Another thing with I-140 is consistency is the key. So it has to be inconsistent and in line with the PERM that has been approved underlying. It is very important to provide all the supporting documents, which includes the degree certificate, the transcripts, education evaluation if applicable, and the experience letter with job duties, job title, and the tenure of work. If the employee has a prior I-140, they can always port that date into their current I-140. The sponsored employee's priority date is current. While filing their I-140, they can concurrently file their adjustment of status too.
And speaking of adjustment of status, that's the grand prize, basically. That's what everybody's waiting for, and waiting to apply for their green card and hopefully get it on a timely matter, which it's not happening nowadays as well. But anyway, so where's the visa bulletin right now? Who is current and who can file their green card application now?
We have the May visa bulletin for 2023 out, and the USCIS has announced that they will use the final action date for employment-based adjustment of status application chart in May 2023. The EB1 China and India applicants whose I-1 485 has not been filed with a priority date of before Feb 1, 2022 can file for their 485 with the USCIS, and for other nationals it remains still current. The EB2 priority dates for all the chargeable areas, Mexico and Philippines, have retrograded to February 15, 2022. EB2 for China is in June 8, 2019, and EB2 priority date for India is Jan 1, 2011, which means any for Indian national whose priority date is on or before January 1st, 2011 with EB2 category can file for the adjustment. And when we move down to EB3, the priority dates for all the chargeable areas, Mexico and Philippines, have retrograded from current to June 1, 2022. EB3 priority dates for China is April 1, 2019, and EB3 priority dates for India remains the same as the prior visa bulletin. It's June 15, 2012. So anybody who has a priority date on or before June 15, 2012, with who is an Indian national and has an EB3 category in their I-140 can apply for their 485. So that's the visa bulletin updates.
Yeah, not a great update, and I mean, frankly, for the almost the whole year, the visa bulletin has been really disappointing, and we just have to wait and see what's going to happen in October when the new government fiscal year starts, and maybe maybe the dates will move, but we just don't know about that. Well, that's all the time we have today. Thank you for joining me, Lily, and thank you all for listening. If you want to learn more about Rise IT Solutions, our innovative projects, and discover new opportunities, you can follow us on LinkedIn, listen to our podcast on Spotify, YouTube, Apple Podcasts, and do not hesitate to reach out. And I'll see you next time. Be well and do good.